Start. Para. By application dated 20th May 1982, each of the petitioners replied the show cause notice containing therein that as copies of all complaints or documents on which the show cause notice was based had been refused despite request, he was not in a position to give a detailed reply which amounted to refusal of a proper opportunity of defense in view of the fact that supply of each copies of complaints, reports, documents was refused. It was clear that there were no such complaints or reports in existence and that the management of the first respondent appeared to have fabricated and collected them in order to support the vague charge against him. During the inquiry on 22nd July 1982, the petitioners made an application dated 27th May 1982 addressed to the inquiry officer in which it was requested that copies of all the concerned documents in the possession of the management be supplied to them. This was strongly opposed by the first respondent, who contended that all such reports had been obtained for considering whether a prima facie case existed for issuing charge sheets to the petitioner, for which purpose alone they had been used, that such reports were not going to be produced at the inquiry, and the result of the inquiry would not depend upon such documents. It was also submitted that the persons making the reports would be examined at the inquiry and would be offered for cross examination. The inquiry officer, by an order dated 22nd July 1982, directed that copies of statements, witnesses recorded prior to the issuing of the charge sheets be supplied to the delinquent petitioners as it was required in law. Strangely, despite the order passed by the inquiry officer, the first respondent maintained its stand that it was not obliged to supply copies of such statements as they were not intended to be used for the inquiry, nor were they being relied upon by its protest. Letter dated 23rd July 1982, addressed to the inquiry officer, the first respondent virtually challenged the direction of the inquiry officer for supply of copies of the previous statements made by the witnesses regarding the copies of the previous reports of the witnesses. The management from the beginning declared that those reports were used to see whether there was a prima facie case for issuing a charge sheet, that those reports would not be used as evidence against the delinquents during the inquiry. It also contended that the witnesses would be examined and the delinquent persons should have a right to cross examine them. In the light of the above contentions, the management felt that it was not necessary to submit the said reports in the inquiry or give copies thereof to the petitioners. Para. Thus, the inquiry came to be conducted without supplying copies of the reports complaints made by the different witnesses against the petitioners. At the end of the inquiry officer, while assessing the evidence, held that as the wording of the charge sheets was rather vague and ambiguous, he was at a loss to know whether the first respondent intended to suggest that there was a pre planned conspiracy on the part of the delinquent persons to beat and his colleagues on that day. He also noticed that, apart from the interested testimony of two workmen belonging to a rival union, there was no independent evidence available on the record. He was constrained to remark. He also adversely criticized the conduct of the first respondent management not making available contemporaneous reports of the security and other officers, and observed that had such reports been available, many of the one-sided allegations about the inquiry could have been dispelled, and it would have been possible to arrive at the truth about how the trouble arose and developed. In fact, paragraph 19 of the inquiry officer's report on the adverse consequences of the failure on the part of the first respondent to produce the reports complaints in question. In fact, in the said paragraph, the inquiry officer was of the view that in all probability both sides had committed acts of assault, giving abuses, etc. But however, in view of the unsatisfactory state of the records in the case regarding circumstances about the origin of the trouble and the motive for assault, in all probability made by the members of rival groups, he had no alternative left to decide the matter and gave his findings as best as he could. The inquiry officer remarked almost plaintively, I have already stated how the evidence of independent person, that is, workmen who owe no allegations to either of the rival unions, is not laid or forthcoming. I also feel that perhaps in the reports or complaints received by the management, names of such independent workmen are likely to be there. Stop.